Hello, welcome to the first episode of Just Peachy. I'm Peachy Thompson and I'm your host. Just Peachy is a show where we interview people who are leaders and subject matter experts in the fields of insurance, taxes, and finances. Now, this show is for the consumers, so once or twice a month, we do have fun where I sit down with people and talk about culture, health, and food. Today's speaker is estate planning attorney Bill O'Leary from Legacy Planning Law Group. Bill, welcome and thank you for joining us today.
Well, thanks, Peachy. Thanks for having me.
Tell us a little bit about yourself and your company.
Okay, well, I'm a lawyer in real life, and I play one on TV as well. And so I've been a lawyer for quite a number of years. And my firm is Legacy Planning Law Group. And what we do is estate planning, elder law, and we also handle what we call post-death administration. So a family member has died, and now the family's come in. We need to administer their estate. On the personal side, I'm married. My wife, Joan, we've been married for, I better get this right, 33 years, coming on 34. And we have two wonderful grown adult children, a daughter, Caroline, who has blessed us with our first grandchild, and a son, Will. So we couldn't be more proud.
Wow, congratulations across the board.
Thanks.
Grandkids, 30, 34 years. Amazing. And do you really play attorney on screen? Because
No, I'm
I
just
was going to
joking.
say,
That's a really
wow.
bad joke that's based on that
Okay.
commercial that you see on TV. So,
Oh, I see. You got me there, Bill. Thank you. Nothing in life is guaranteed, as I was talked to people about, but I do know
hmm
that there are two things that are certain, and I know you would agree. The
hmm
first one is the fact that you're going to die. The second part is that you're going to pay taxes, right? So
right.
in your practice, uh, things like wills, trust, probate, these things come up. Can you educate us a little bit about those things?
Sure, I'd be happy to. You know, uh, uh, estate planning is sort of the overarching description that we use. It's something that people tend to put off. They don't want to think about it. I don't know whether maybe in past generations it was more of a superstition thing. Oh my gosh, if I sit down and write a will, I'm going to die, kind of thing. Or it is, none of us want to think about the end and want to think about death, and so we keep putting it off, and so it may sort of over time work its way towards the top of the pile, and then other things take over, and it moves to the bottom. But really, in fact, studies show that about 6 out of 10 of us, 60% don't even have, just a basic simple will, let alone something a little bit more than that. And so, really, um, it is a way, in my judgment, for you to show your love for your family. Everybody's heard of a will, a last will and testament. It's really a way for you to, again, take control in answering four very important questions that are very important and personal to everybody. Number one, you decide who gets your stuff, who gets your money, your assets, who gets your stuff. Number one. Number two, you decide what they get. What they get. Number three, you decide when they get it. And number four, you decide how they get it. And in fact, that last question, the how question, is as important as the first three. But let's at least answer the first three, and then we'll get to number four. So the who, what, when, and how. Okay. So what happens if you don't answer those questions down on paper the way that you want? You don't put it in a will or something like that. Well, does that mean that you don't have an estate plan? Well, the answer is no. You still have an estate plan. It just may not be the plan that you want. It's the plan that the government will dictate to your family who gets what, when, and how. Okay, and so again, a will allows you to do that. and so it sets very clear expectations. Everyone knows exactly who's getting what and why you're doing it, and you can do it in a way that maybe will protect them. So that's the 4 out of the 10 of us that at least have a will in place. What about the 6 out of 10? Well, you might end up leaving a mess for the family, and I can't tell you how many sort of clients that come into us. It's really the family members whose loved one has passed away, and they didn't plan as well as they could. Maybe they didn't even have a simple will in place to answer those 4 questions. Maybe they didn't have something a little bit more precise in place, and now the family finds themselves sort of stuck. What do I mean by that? Stuck, sort of bogged down in the court system, and none of us likes to be sort of involved in the court process. So what I'm talking about there is probate, and we can talk about that in more detail, Peachy. But they find themselves stuck in probate, and a lot of times the family members, let's say the adult kids, will say, well, "Why are we having to do this?" Well, because mom and dad, they didn't plan as well as they could. So
I agree. I agree, Bill, that a lot of people tend to not want to talk about this. And this is excellent stuff. You just gave us a background on. If someone wants to create a will, and it sounds like it's something that should be automatic and easy to figure out, but not a lot of people do it. What are the ways for them to have a will created?
good question. So, nowadays, we are not wanting for information and resources. I mean, it's just a few keystrokes and you can access a lot of stuff out there. The internet is full of a lot of stuff. The challenge is sort of sorting through the information to decide what's good and what's not so good, what's reliable and not so reliable. So, you know, there are wills that you can do online, LegalZoom. I'm sure, people have seen the commercial where you can do a will online. Um, uh, that is a big risk, not because I consider LegalZoom as sort of a competitor. I don't, because they run the risk of not doing it correctly. And just sort of a case in point, there was a legal case that was litigated here in the state of Florida that went all the way up to the Florida Supreme Court. I think it was 2013, 2014, where there was a dispute over a will. And the problem was that this will that was done online, okay, lacked a very sort of basic common type of legal provision in it, okay, that you would expect to see in a will. Didn't have it. And so it caused a lot of family infighting. They litigated this will, and it went up to the Supreme Court and ended up basically getting invalidated where nobody was happy. And it's interesting, one of the judges on the Supreme Court in this written opinion wrote a little paragraph, and it was words to the effect, this is why you hire a lawyer to do a will. And, just jokingly, I probably should, cut that out and frame it. The point is, yes, you can get it online. Big mistake. You're much better advised to go talk to a lawyer, because again, when you go to a lawyer for a will or estate planning, at least sort of the clients that I prefer to work with is not somebody that's just coming in for a legal document, because you can get that anywhere, but instead is coming to me to allow me to sort of get below the surface level and to want from me advice and counsel, not just a legal document, but advice and counsel, which, by the way, is still hard to find on the internet, advice and counsel. And so again, that's always my advice. Go to a lawyer that you're comfortable with and get the professional help.
It is, you hit the nail on the head there, Bill. It's the getting beyond the surface. It's really important. And we can Google a lot of stuff nowadays, and I know that people do that all day long, but nothing really replaces a deep relationship with a professional that does what they do best. So you mentioned probate. What is probate?
What is probate? And a lot of people have heard of it. Um, maybe some people may not really know what it is. Other people sort of do know what it is, or maybe they've had a family member that has had to go through it. Maybe they've experienced it personally with, mom died and the kids had to probate the estate. um, but probate, in essence, it's a court process. It's a process whereby the court system gets involved, and the deceased person's estate. And by the way, when I use that word estate, I hope that people don't check out on me and just say to themselves, well, that doesn't apply to me. That's just, Mark Zuckerberg's of the world. No, everyone has things to pass on. Okay. Everyone has an estate, big and small. But probate's a process whereby your estate is going to be administered, okay, by somebody with the oversight of a judge, a probate judge. So what's the big deal with probate? Well, probate can be a big deal. There are two principal sort of problems or issues that we see with probate. Number one, it takes a long time. It takes a long time. So for a regular sort of, probate, in my experience, it takes between 9 and 15 months. And if you talk to my probate paralegal, we've got a number of them in the office that are spilled over sort of into year 3 because things sort of pop up unexpectedly that you have to deal with it. And it's only so much we can sort of push it along because they're sort of built in requirements and things that have to be done with time frames in them. So number one, it takes a long time. And so what that represents, it's a period of time during which the estate is sort of frozen. And maybe your loved ones, let's say the kids, can't get what you would like them to get, what they might even need to get. They can't. And problem number 2 is it's expensive. It's expensive. And by far the largest expense comes into play because in Florida now, a lawyer has to be involved in the probate case. In most every probate case, a Florida attorney has to be involved, has to be hired by the executor to represent them. Okay. And so, well, why is that a big deal? Well, the lawyer is going to get paid for their service, right? And that fee, according to the Florida law, says that can be based on a percentage of the value of your overall estate, between 3 and 5%. 3 sort of a baseline. It can go up to 5 if it's more things involved in the estate. So it's the way I look at it is it's not planning well enough so that the kids don't have to go through that. It's like taking money unnecessarily right out of their pocket. Florida is kind of notorious for having sort of especially sort of prolonged, protracted, and expensive probates compared to other states.
It does sound like we definitely don't want to be involved in probate. And just hearing you talk about this, it's like, as a consumer, I'm either taking care of my will, paying maybe an attorney to do it in the beginning while I'm still alive, or do I just let it go and let probate happen? And either way, the money's going to come out of my pocket.
Right.
So
That's
is
right.
it I give that control to the state, or do I exercise that control when I'm still alive?
Yeah, and it's interesting that that question, because it's usually much less expensive at the front end to take care of it now. Okay. And so what the client is doing is saving the family that back end cost, which is a lot more. But I have had on occasion a client that says, well, I don't care. I won't be here anymore. Let them figure it out. But most clients love their kids enough.
Right.
They want to save their kids that back end expense.
Don't put them through that. Definitely. Yeah. Speaking of kids, when we talk about kids, I have 2 kids. Let's talk about inheritance. Right? So is there a way to protect my kids' inheritance if in the future, they'll get married, they'll have their own family and whatnot? I know divorce is something that's very, very common nowadays. Right. I'm hoping that never happens for anybody, especially my kids, right? But is there a way to protect their inheritance in the event of a divorce?
There is, and that actually is a fairly common concern that parents with adult children have. Some actually already sort of have that concern that they've developed, and they come in to express that concern. Others sort of have it in the recesses of their mind and really haven't sort of crystallized it yet. But
Mm-hmm.
but in that conversation, in that initial conversation that I have with them, it sort of they are led to discover that. And
Mm-hmm.
so the one thing that they don't want, as much as they, again, they hope and pray for long-term marriages, but we
Sure.
know the statistics, the last thing that they want is to see half of their child's inheritance going to the ex-son-in-law or daughter-in-law. We could call it the outlaw. Um, and so they want to keep the money in the family. And so that is, one of the two biggest risks, if you will, or threats to any adult child's inheritance is the possibility that they get divorced. The second uh, biggest risk is, it's one that any one of us sort of faces. We go about our daily lives,
Mm-hmm.
which is the car accident, and the lawsuit comes, and now they're trying to find assets to satisfy the court judgment, and so the divorce and lawsuit a risk. And so the question is there a way to protect the child's inheritance from that?
Mm-hmm.
And the answer is yes. And what that would look like is making sure that when you die, a trust is sort of in place that you've set up before you die, but a trust is in place. Think of a trust as nothing but a lockbox, and so the inheritance will go to the adult child, but instead of them sort of receiving it outright, so it drops in their hand and they put it in their pocket and off they go, when it's then exposed to the divorce and the lawsuit, it drops into this lockbox. And this lockbox, as long as the money stays in this lockbox, it's protected from the divorce and the lawsuit. But there's a wonderful solution for the what I call the responsible adult child. So, the adult child that is, pretty good with money and doesn't have an addiction problem and so forth. But they're subject to the same two risks that any other adult child is: the divorce and the lawsuit. Is there a way that we can protect their inheritance, but also put them in control of their own inheritance? Basically, put them in control of their own lockbox. And the answer is yes. So this lockbox is a trust. They then can be the trustee of their own trust. If you were a Peachy in my office right now, I would be up on my whiteboard and I'd be, giving you a visual of what a trust looks like and so forth. And this lockbox, at this point, I would take my eraser and I would erase half the line to the box. And what that signifies or shows us is that the door to the lockbox is open. There's money inside the lockbox, but the door is open. And
Mm-hmm.
the adult child is able to reach their hand in and take money out of the lockbox anytime that they want. So then I'll ask the question to the client, but is your child going to reach their hand into that lockbox and take all the money out the next day or a week after your funeral? Are they going to do that? And the answer is no, because you've told me that your children are responsible adults. They'll appreciate what mom and dad have done for them, which is to build for them, the kids, a lockbox with mom and dad's money where it can be protected from the divorce and the lawsuit. Understanding if they try to do this same thing themselves to get the same protection, they
Mm-hmm.
got an outright inheritance and they walked across the street after, they got the money and they went to a lawyer and said, hey, build for me a lockbox so I
Mm-hmm.
can protect it from the divorce and the lawsuit. Doesn't work under the law here in Florida, but mom and dad can build for them a lockbox with mom and dad's money. And
Mm-hmm.
then, so back to the me erasing half of the line. What that is showing us is that the door to the lockbox is open. They're going to keep most of the money in there, understanding as long as it stays inside the lockbox, it's protected. They may take some out sort of as needed for living expenses, but keep most of it in there. And then the door to the lockbox will be open as long as everything is going fine in their life. So the analogy that we can use in Florida, summer times in Florida. Peachy, what are most mornings like in Florida aside from hot and humid? Most mornings usually are sunny.
Yeah,
What
beautiful.
happens a lot of afternoons, almost like clockwork?
It rains like crazy. Thunderstorm.
Thunderstorm. So what
Mhm.
might a thunderstorm be in the adult child's life? Serve with divorce papers. So when that thunderstorm happens, what happens to the door to that lockbox? It shuts. And while the storm is swirling around, so the divorce case is going on, the door is shut, and the money in the lockbox is off limits to the divorce. And then to sort of put a postscript on it, what happens when the storm ends? Sort of skies clear, divorce case is over. What happens to that shut door? Well, you guessed it. It
Okay.
opens back up, and the child then has access to the money again. This is an example of something, sort of a point of emphasis at my firm that we call family protections. This is an example of a family protection, a way to protect the adult children.
Very good, Bill. Very good. This is really very informative. Um, Let me ask you about the lockbox. So the
Hmm.
lockbox, it's designed to protect my kids, for the storm in your analogy. So does the door open and close automatically when it's sunny? It's open automatically. When the thunderstorm comes,
Hmm.
it closes automatically, or do they need to do something to trigger that?
That's a good question. That's a good question. So the short answer is it does not close automatically. Something has to happen to close it. And if you'll just to walk with me for a minute down into the weeds, I'll stay there for just a second, and then I'll come back up for air.
Okay.
And so there's a mechanism that I like to use in my trust, where somebody else, other than the adult child, is the one that closes the door and opens it back up. It's a role that we call the trust protector. And actually in the trust that I prepare, oftentimes my firm is named as the trust protector. So the reason why we want somebody else to shut the door rather than the adult child is we don't want the adult child's fingerprints anywhere on the closing and opening of the door. Because if you think about it, if the child had that power to
Mhm.
shut the door, well, what would the divorce judge tell the child to do? By golly, if you have the power under this trust to close the door, you are hereby ordered to
To do
open the
it.
door. So we don't want to give the child that power. We give it to somebody else, the trust protector. Now, in the real world, the trust protector, let's say it's my firm, isn't necessarily going to know that the child has just been served with the divorce complaint.
Mhm.
So the children will have to, again, this is the way we do it at my firm. They will know who we are. Their parents will have already introduced us to the adult children. And they'll know about this lockbox that's been created. And so if they happen to get hit with that thunderstorm, they need to pick up the phone and call us. So that's how we do it.
Mhm.
Other lawyers may do it a little differently, but it's important that for this opening and closing of the door to work and for the assets to be able to be protected, we can't give the power to the child to open and close the door.
And it sounds like, Bill, it's the same idea, the same reason why the child can't take an inheritance and go to a lawyer down the street and create their own lockbox. Because that it sounds, that if I do it that way, that would give the child or me, if I did it, control of the lockbox. Let's back up a little bit and tell me about when do I need estate planning,
Hmm.
right?
An estate is probably sort of a more generic term. It basically applies to everything somebody owns. Okay. When they die.
Hmm.
So at that point, the estate is going to go to somebody, or somebody's, what are called the
Hmm.
beneficiaries. How it gets to the beneficiaries will depend on how well the deceased loved one planned. Um, it's either going to have to go through the probate court, and we talked about that. The lengthy delay and the expense that comes with it, or it can get to them in a way that avoids the probate court, that avoids that 9 to 15 months on average, 3 to 5% going to the lawyer. And a very common way that is used to to make sure that the kids are not bogged down in the probate court is with a trust. So a lot of people have heard of a trust, but not many really understand what it is. And that's okay. That's okay. Most people don't live and breathe it like I do, just like I would need help, doing an engine repair on the car.
Mhm.
And so think of a trust as nothing but a box. And I would say this box is a trust, is a trust. It's a trust for you while you're still alive. That's why this is often referred to as a living trust, as a living trust. And as part of this living trust, this building of the box, it allows you to answer four very important questions. These are going to sound familiar, Peachy. Who gets your stuff, what they get, when they get it, and how they get it. The who, what, when, and how. Well, a will, I've already told you, answers those same four questions, right? So if a
Mhm.
will does and a trust does, well, by golly, what's the difference? What's the difference? Here's the difference: is if you have a will, which, hey, is better than nothing at all, is better than having the back of a napkin, because at least a will keeps the government out of it.
Mhm.
But if all you have is a will and that's it, then it is quite likely that the family, the kids, are going to have to go through the probate court. And actually, that comes as a surprise to people when I tell them that, because a lot of them, people will say, "Hey, I've heard of this probate thing. Don't want the kids to have to go through it, but I have a will, so I've solved the problem, right?" The answer is, unfortunately, no, that's not right. So a
Mhm.
will often is just a start. So then, how is a trust different from a will? Again, a trust answers those same four questions. With a trust, that when you die, or if you have a married couple, at the second spouse's death, the kids are not going to be stuck in the probate court. So they're saving that 9 to 15 months. That's, again, that 3 to 5% that could be going to the lawyer. So that's the principal sort of reason why a living trust, again, a trust for you while you're living, is
Mhm.
put together, is to make sure that things go smoothly and easily to the kids and not having to go through the probate court. That's sort of objective or goal number one. Number two is, if you want to protect the child's inheritance, like we were talking about a few minutes ago from the divorce and the lawsuit, that is best done within the four corners of your living trust. So again, just picture you in my office, and I'm drawing you the big box. That's your living trust. Now I'm going to draw, and this is probably backwards for you. No, here we go. Picture this is the lower right hand corner of the box. I'm
Mhm.
going to draw a small box inside the big box. That small box is that lockbox for the kids. So when you die, they're not having to go through probate, number one. And number two, their inheritance is going to be able to drop into this lockbox to be protected from the divorce of the lawsuit. So that is a second use of a living trust, is to build this lockbox. If somebody doesn't feel the need or the importance of building the lockbox for the children and just sort of wants to let the chips fall where they may, that's okay. We can still put together a big box, a big living trust for them, to make sure the kids don't have to go through probate, but we just won't include that small box, that lock box in the lower right hand corner.
Wow, that's a very good, and I'm a visual person too, so I love the analogy of the box and the small box that is for my kids, right? So
Mm-hmm.
as you're going through this, Bill, where you're having to create the living trust for someone like me, for example,
Mm-hmm.
um, when when does it make sense to do a, I would call, a full blown estate planning?
Estate planning, um, I think, includes sort of getting sort of into the game by putting at least a will together. Okay. And it also includes sort of taking the next step and putting that living trust together. So when would it be appropriate for somebody to just sort of get that entry point, that will?
Mhm.
And when would it be appropriate to consider sort of taking the next step, upgrading, if you will, to that living trust? Well,
Mhm.
let's start off with the will. You have, a single person, they're probably just fine without a will. Let's say they get married. Um, If they own everything together, as husband and wife, then they're probably okay not getting a will, even though they're encouraged to. Most don't. Guess when it changes
When
is
they get to.
when that first child is born. When that
Oh,
first child is born, now it's not about two, but it's about three. Okay.
this is
So
true.
they come in and they say, well, now we're concerned. What if something happens to both of us? We're out on date night and we don't make it home, tragically. Well, who is going to be the guardian of our new child? Who's going to take them into the home? Okay. And so a will is sort of a great sort of entry point to do that, because a will allow you to be able to name a guardian for your child, okay, and be the guardian until they turn age 18. A will can also include that same lockbox that I talked about. So picture with a will, I'm going to draw another box. This happens to be the will box, not the living trust box, but we can have the same a lockbox in the lower right-hand corner. That would be a trust for your child. Here, the trust is inside of a will,
Mm-hmm.
and that trust for the child is often what we call an age-based trust. So it will establish sort of an age, maybe age 25 or 30, certainly older than age 18, because I know most 18-year-olds probably are not yet ready to handle an inheritance. Then if the parents pass away while certainly the child is a minor, this lockbox is a necessity, because then the inheritance will drop into this lockbox in this trust for the child, and that will avoid having to open up a guardianship case in the court system to receive the inherited money. So that trust, that lockbox, is inside of the will. And a lot of times parents will want to sort of continue that trust, as I said, beyond age 18, age 25, or age 30. And so that's sort of the entry point for younger couples. Okay. Now, the one downside to that is that with a will, that in order for that trust to sort of kick in for the child, it does have to go through the probate court. So the assets are going to have to be probated before that money drops into the lockbox for the child. But usually with a younger couple, sort of the risk of death is very, very low. And so it's a manageable risk, and it allows them to sort of get into the estate planning arena at a much lower price point. A will is usually more than adequate, but once that first child is born, we need to also add this lockbox.
I think there's a common misconception that until you have a huge estate, you don't need to see a lawyer to plan these things, right?
Mm-hmm.
And that's common. I have a lot of clients that I'm not even surprised anymore that they're in their 50s or 60s and they have enough assets that's just been sitting somewhere,
Mm-hmm.
and they never even thought about consulting a lawyer about their estate, because in their minds their estate was not an estate, that it was small. It was too
Right.
small to even have these plans.
Well, picture this, Peachie, and this is something that you're certainly well familiar with. You've got a married couple, and they have a young child or children, and they have a life insurance policy. Maybe it's a term policy that they get fairly inexpensively, and as you know, Peachie, that with a life insurance policy, you can name a beneficiary on that policy, and so at your death, it will go to that beneficiary straight away. Okay, no need to sort of involve the probate court, so that's a good thing. But a lot of times, I will find out that this couple has named as the backup beneficiary what's called the contingent beneficiary after the spouse, the kids in their own name. Well, what would happen if they were to die together in some car accident, and now that life insurance is going to get paid out to the contingent beneficiary, the kids, the 7 and 5-year-old in their own name? Well, legally, they are not able to receive that life insurance payout. They're not. So a guardianship is going to have to be set up in the guardianship court. And oh, by the way, that guardianship is going to have to remain in place until they're age 18. So that's where, in that situation, having a will in place, but with that lockbox, with that lockbox, that trust inside of the will is ideal, because then the contingent beneficiary, the wording could be just changed to have it paid into that lockbox if it falls down to the kids. And so, that's it's such an easy solution, but it's not that people are intentionally doing it wrong. They just don't know. They just don't know. You know.
Right. Right. And Bill, I've seen exactly what you've described time and again. And it is very common. It's because it's easy to perhaps gloss over and just unintentionally doing that, and has caused some problems. So that's really good. That's a very good thing to point out.
Yeah, yeah, so then when would it be appropriate for somebody to consider to sort of taking the next step and getting that living trust as the alternative to a will? Well, it usually by the time people get into their 50s, certainly their 60s, I have the trust conversation with them, because they're closer to death than they were in their 20s and 30s. And how many assets do I need to make it sort of, worthwhile?
Yes.
Well, let me ask you this. I'm sure good in math, Peachy. If you've got sort of a $500,000 in assets, sort of all together, the attorney's fee, if those assets had to go through probate between 3 and 5%. Let's even take the low end, the 3%. What's 3%, Peachy, of $500,000? It's $15,000. So that's what you're sticking the kids on the back end with, that cost. Well, you could on the front end plan better to put a living trust in place at certainly at a lower price point than $15,000.
Good point. And that goes back to what I was saying earlier, even just the will, right? It's either you're paying that lawyer's fee up front while you're living, or you're having to put your kids through this emotional roller coaster of going through probate. And at the end of the day, those fees are going to come out of your estate anyway. So it's a matter of choice. Do you want to have control of that, pay it before, or let it be and let someone else decide for you and pay it after?
Most parents love their children too much to stick them with that.
Yeah, let's hope so, right? So, and I always joke around that people who come to people like you and I are those people who love someone else besides themselves, and it's really what this whole conversation is all about. Because as you said in the beginning, you've had clients where they've come to you and say, "I don't worry about it. I won't be around," and they'll just do it themselves. Let them figure it out, right?
That's
So
right.
I've had clients come to me and say, my mom or my dad just don't want to talk about these things with me.
Yeah.
Right. So
That's hard. Yeah.
How can we help those people? What would be your advice for those people?
Yeah. So it can be a hard conversation, and maybe it's kind of a generational thing that over time we're going to see less and less of that. But some older parents are really reluctant. They don't want to talk about it, but that should not be a reason for the children to not try. So you need to get in there. You may have to ruffle a few feathers, and I encourage the kids, if they're having a difficult time doing that, is to get the parents into the office, because I find that once somebody comes into the office and we get past the first few minutes and I make them comfortable, I'm able to explain to them that maybe in a way that the kids can't, the importance of having this. But sometimes they tough love. And
Yeah.
hopefully the parent is willing to cooperate and get in the car and come down.
Yeah. Are there any other maybe tips that we can give our viewers as far as how do you start that talk? Yeah.
I think that the best sort of segue to that is not talking so much about the money and the assets and who's getting what, but to talk about end of life questions. Okay, mom, dad, so have you thought about what you would like, or maybe what you don't want to be given to you if you, let's say, have a terminal condition. Do you want to be put on a machine, mom, dad, or not? Who do you want to, if you get to the point where you're not able to really make those important decisions for yourself, whether it's healthcare or financial, would you like our help? And I find that's a softer sort of conversation and ask to make, and then that then can sort of
Lead on.
expand the conversation and lead to to some of the other questions, will, the money and that sort of thing. But it's really I think it's the end of life question, which probably is in the back of their mind at that point in their life anyway, that really is the icebreaker.
I think most people, if you come out of concern, if you ask them questions out of concern, it's easier for them to open up. So rather than talking about money right away, hey mom, hey dad, am I getting the house, the lake house, or the ski
Right.
condo? Let's talk about what you want to do when it comes to your health and your aging. The reason I picked you to be my first speaker is the fact that I do know that you're a genuine, just an overall good person. So I'm sure that the
Thank you.
clients who go and see you are just as impressed. On that vein, if any of our viewers have any questions, what is the best way for them to contact you or learn about you?
Okay, sure. Well, you can Google us. The law firm name is legacyplanninglawgroup.com, or if you put in estate planning lawyer Jacksonville, I think we'll come up fairly high. But again, legacyplanninglawgroup.com. The number here at the office is 904 880 5554, 880 5554. We are a Jacksonville firm. I love helping people, and Peachie, I really appreciate this opportunity to be on your inaugural podcast.
My pleasure. Thank you, Bill. Thank you so much again. And I look forward to seeing you at the next meeting. All right.
There you go. There you go. And as I like to close with people, go make it a great day and a better world.
Bye, Bill. Thank you.
Okay. See you, Peachie. All right. Bye.